Hello everyone, my name is Sai CHEN. Welcome to Linda Liu IP course. As trademark is such an important business mark, trademark infringement has been the most commonly used means for imitators. With the severe crackdown action on trademark infringement cases, especially counterfeit cases, which may be prosecuted for criminal responsibility, imitators have begun turning their attention to packaging and decoration. For example, this one and this one. When trademarks are neither identical nor similar, can the right owners take actions against such package imitation? Of course they can. According to the item 1 of paragraph 1 of Article 6 of Anti-Unfair Competition Law, unauthorized use of signs which are identical or similar to others' product name, package, decoration with certain inference shall be subjected to unfair competition in cases where such use may easily cause people to confuse the products or their relationships. The applicable conditions of this clause can be summarized as popularity, distinctiveness, and similarity. The fundamental criteria is whether such use may cause confusion or is misleading. To obtain the protection of anti-unfair competition law, firstly, the product shall have a high popularity in China. Advertisements in newspapers, magazines, and various media, invoices that reflect sales volumes, financial reports, market share rankings, and various award records are all strong evidence of popularity. Secondly, package and decoration shall be distinctive, not common, and it is necessary to enable the relevant public to connect the package and decoration with the product. Generally, if the same package and decoration are used for a long time and the package and decoration are faced with the relevant public during the whole promotion and sales, it can be considered that the package and decoration are distinctive unless there is any evidence to the contrary. When the product has a high reputation and the package and the decoration are distinctive, the use of similar package and decoration, which easily cause confusion and is misleading, constitutes unfair competition. The right owner can file a complaint with the local market supervisory authority or file a lawsuit before the court. However, as whether the package and the decoration constitute rights and interests of certain influence stipulated in anti-unfair competition law is not as clear as registered trademark rights. The market supervisory authority may have many concerns when handling such cases. Also, compensation cannot be claimed through such administrative means. Therefore, it is recommended to file a lawsuit against such imitation of package and decoration. Our firm has dealt with many cases. All of them have achieved good results. Not only imitation is seized, but also high compensation is obtained. The first tip: the evidences of popularity such as use, publicity, awards, and so on shall be well preserved. A file of evidence of popularity can be established within company or under the support of a long-term cooperation law firm. Such file can be used not only in the unfair competition cases regarding package and decoration, but also in cases of trademark infringement, invalidation or opposition proceedings against the preemptive trademark applications or other unfair competition cases such as corporate name imitation. The second tip: pay attention to maintaining the consistency and continuity of package and decoration. Although we understand that in practice, the package and decoration often need change due to product upgrades, it is advisable to maintain the core identification part or maintain style consistency when making changes. The third tip: it is better to obtain the rights as many as possible. For example, the prominent logo on the package should be applied for a trademark as soon as possible. The overall shape of the package can be applied for design patent, and the entire design can also be subject to copyright registration. The protection scope and the conditions of protection of these rights are different. The more rights you own, the better. More effective and comprehensive protection can be achieved with various rights obtained. The fourth tip, the rights and interests of packaging and decoration are attached to the product. However, since there may be other rights in packaging and decoration, when these rights holders are not consistent with the manufacturers or operators of the product, there may be disputes over who is the real owner of the package and the decoration. Therefore, if multiple entities are involved, it is important to reach a clear agreement on the belongings of the rights and interests. In practice, especially in the case of trademark license or manufacturing consignment, the trademark owner and the manufacturer or operator of the product are different entities. In order to avoid disputes, it is better to make a written agreement in advance. Finally, according to the Supreme People's Court of China, there are two types of decoration. In addition to the decoration of the product surface, the shape and external structure of the product itself may also constitute decoration. Of course, it requires higher popularity and distinctiveness of the product and design when claiming the imitation of shape constitute unfair competition. Due to higher requirements in judicial practice, there are not many cases where the shape of a product is determined as decoration and has obtained the protection of anti-unfair competition law. But it is entirely possible. These are all successful cases. For example, the case of the famous Swiss watch Royal Oak is handled by our firm. Despite considerable difficulty, we succeeded in obtaining a favorable judgment. If you face similar troubles or worries, please feel free to contact us. We will try our best to assist in protecting you against various imitations.